from the Court of Appeal of Guernsey involving AFR advocates and Mr. and Mrs. Lovering. The appeal is being heard remotely, with each of the lawyers and members of the board sitting in different locations in accordance with the United Kingdom government's instructions in response to the coronavirus pandemic. We have as yet only limited experience of hearing cases in this way and ask parties to be patient to allow our IT team to address any problems which we may encounter. I hope we will not encounter any. The live stream video will of course look different to our usual output, but we hope that it will serve as a satisfactory record of the proceedings. We will make the footage from today's hearing available on demand via our website within 48 hours. In order to reduce interference and echoes and prevent the camera from being attracted to someone other than the person speaking, I have asked the IT members of staff hosting this meeting to keep muted the microphones of everyone other than the person speaking at the time. If you wish to speak while someone else is speaking, please indicate by raising your hand so that the speaker can see and pause to allow you to speak. When he or she does so, would the person who then is to speak please pause briefly before speaking to allow the IT staff to unmute your microphone. I turn then to introductions. I will invite my colleagues to raise her or his right hand as an introduction when I say their names before inviting counsel to introduce themselves. I am Lord Hodge. I will introduce my colleagues now and pause to allow their images to be displayed momentarily in the broadcast. Lord Briggs. Lady Arden. Lord Kitchen. Lord Sales. Thank you. May I invite Mr. Mark Ferbresh to introduce counsel and then proceed with the appeal. Thank you.
Advocate Mark Ferbresh.
Mr. Barnes?
I'm Nicholas Barnes, appearing for the respondents to the appeal.
Thank you. Mr. Ferbresh, if you'd start the appeal.
I'm obliged, Lord Hodge. What I was proposing to do, members of the court, if it's convenient to you, is to proceed on the basis, obviously, the papers have read, and focus my attention on the three questions, three issues identified in the email I received at 16:23 yesterday, if that's most convenient to the board. The first question, which the board indicated that would be of assistance to be addressed on, I will deal with this one, and that provides the status of the plan 4782 attached to the 1968 conveyance and referred to in the 2009 conveyance as a means of ascertaining the western boundary of the access tract. And in that regard, members of the court, I believe it would assist if we looked at paragraph 102 of the judgment of the Court of Appeal, which is to be found at page 51.
You did? Okay, you didn't show on the website?
Oh, fuck.
Because I could hear you clicking around, and I wasn't sure if that's what you were doing. Yeah, I don't think it showed on the website. It did show the QCs though.
Right, because that's on the auto thing. Okay.
is in Newton, by the way.
Yeah, I've just done it.
And Hodge is in Newton either.
So it didn't do it on the website?
No, it didn't do it, I don't think. He was saying Lord Briggs, whatever, and it didn't switch to. Probably doesn't
In the preceding paragraph of 101, the Court of Appeal had observed that together with the Royal Court, the plans numbered 4782, that the area in blue on 4782 and 2842 is the same. And then they go on to observe, or rather make the finding, at paragraph 102.
I see.
In this situation, we reach the same conclusion as we did in the case of the plan numbered 2842, as it was annexed to the 1960 conveyance, and for the same reasons. The only difference is that the plan is referred to in the 1968 conveyances indiqué sur le plan. But these are not words of limitation.
My mistake in the group.
My submission, therefore, is if they're not words of limitation, they must be identification.
See you later.
So the Court of Appeal itself found that the plan is not limitation, it's identification. And they reached the same conclusion in relation to plans 2842 and 4782, and that's consistent with the finding of the Royal Court. So that will inform my respectful submissions in relation to your second question in due course. That was the correct finding. I would suggest is fortified by the 1968 conveyance itself, which is at volume 3, page 451, because when describing the lisière de terre, i.e. the area in blue, it refers to it as being de 10 pieds ou environ, i.e. 10 feet or thereabouts, the lays in width. It also uses the word indiqué, which is what the Royal Court and the Court of Appeal focus on as meaning by way of indication as opposed to limitation. And then the words of description in that same conveyance go on to say at the material boundary, des bornes entre deux. So in other words, what you have, they make a finding that the plan itself is by way of indication, not limitation, and the words of description of the western boundary are des bornes entre deux, so boundary marks, which is what the jurats sought to determine the position of at the vue de justice. So the jurats needed to determine that as an issue of fact, which is what they did. But what flows from that also informs the second question, which the board has raised with me, and members of the court, if it's acceptable to you and you would find it useful, I will read that second question, which I propose to address. The second issue or matter which the board wished to be addressed on is whether the parties take issue with the Court of Appeal's summary of the law in paragraph 86 of their judgment, and if so, in what respect. And paragraph 85 is to be found in the bundle at pages 48 and 49. And if it's convenient, members of the court, you may just wish to read to yourself paragraphs 86 before I move on. So, members of the court, I do take issue because I believe, having correctly cited from Wigington and Milner and Webb and Nightingale, that it's my respectful submission that the judgments of Lord Justice Romer in Webb and Nightingale, and that's to be found at page 47, paragraph 81, and also on page 48, Wigington and Milner. And it might be useful, members of the board, if you were to read paragraphs 81 through to 85, if that's most convenient.
I'm so sorry, 81 to 85 of the Court of Appeal judgment, or
Yes,
something else?
Yes, Lord Briggs, and that's on pages 47 and 48 of the bundles, Your Lordship.
Thank you. Thank you.
Your Lordship, Lady Arden, what you have noted that our Guernsey Court of Appeal took guidance from the Court in the Court of Appeal in England, and particular Lord Justice Romer in Wilson and Green. And I believe the material part of the judgment which is cited by Mr. Justice Collins in Guernsey is in the parentheses. So if you're with me on the point that the Court of Appeal, having found that the plan was not by way of a limitation, it must be therefore identification, the material part of Lord Justice Romer's judgment is this, in the appendix, it says, in such cases, the plan is merely to assist identification and in the event of inconsistency arising, is subordinate to the verbal description. And I would respectfully submit that's entirely the correct approach. And here we have a plan which is by way of identification, and the words of description of the western boundary are des bornes entre deux, and there's no ambiguity or uncertainty as to what is described as the boundaries, boundary marks on the western side of the driveway. And Lord Justice Romer's approach is entirely consistent with those of Lord Justice Buckley and Lord Justice Bridge, which we find in Wigington and Milner, and which is cited with the approval of paragraph 83. And the material parts of Justice Buckley said is, where a court is required to decide what property passed under a particular conveyance, it must have regard to the conveyance as a whole. So that obviously would take in the words of description, des bornes entre deux, including any plan which forms part of it, but here the plans by way of identification. It is from the conveyance as a whole that the intention must be ascertained. And of course, that's absolutely correct, being en contrat, as we call them in Guernsey, basically for the sale and purchase of land. The court is seeking to determine what is the intention of the parties. Now, the jurates made findings as to what the intention of the parties were, and the Court of Appeal did not disturb them, but said that it's not necessary, we don't need to make findings of intention. With respect, that's directly contrary to what, for example, Lord Justice Buckley found, because it's a contract and you must work out the intention of the parties. And just pausing briefly, I'll visit the submissions, the respondent's case, but for you to note, members of the court, at page 2889 and paragraph 2.5, what is submitted is that the Court of Appeal did not wrongly disregard findings of the jurates. In other words, to state that positively, were correct in disregarding the findings of the jurates in relation to the topography of the site or the position of the boundary marks, or disturb any findings of fact, as the defect in title as pleaded by the respondent was made out as a matter of law by construction of the conveyancing documents, key words, without the need to find any facts. Well, the jurates needed to determine objectively what were the intention of the parties, and they did. And you do have to make findings of fact, because where the words of description refer to des bornes, it's an issue of fact of where those bornes are located. And that requires a vue de justice, which is what the jurates carried out. Or put another way, a site visit, go out and site, and as everybody says, look at the topography of the land and look at the western boundary, because the Hardings, who own the property on the western side now, make no claim to any part of this driveway. And so what the further part of Lord Justice Buckley's speech, he says, is this: the process of identification is in fact the process of discovering what land was intended to pass under the conveyance, and that is the precise purpose which the plan is said to serve. So in circumstances where the plan's by way of identification, it assists, but it is not determinative of the boundary. What's determinative of the boundary is the words of description in respect to which there's no uncertainty, which is de born entre deux. And as you'll see when I come later on to this, you can see that actually when you get to what the Royal Court referred to as the dogleg, as it's greater than 10 feet, and you couldn't perform the exercise if you like walking down the edge there with a 10-foot pole and following it round the corner. And in fact, the appellants accept that because in the submissions to the Court of Appeal, they themselves accept that actually it couldn't be 10 feet in the dogleg because you couldn't have vehicular access because in effect the angle's so acute. Parking, the fact that the land itself in the dogleg was about 5 feet high, and at the time of the conveyance in 1960 and subsequently would have required for the land to be excavated. This is back in 1960 in Guernsey, which is, I would respectfully say, a bold submission. And the jurors found that so highly unlikely, and that informed their decision on the intention of the parties. Furthermore, we know from the Ordnance Survey maps what the jurors noted was that the location as the driveway, which has been there since 1960, is consistent with what was shown on the 1963 Ordnance Survey map. An advocate.
Should we have a look at the 1963 Ordnance Survey map? That might be of assistance.
Very
Thank
good,
you.
sir. You find the reference to that one. Yeah.
Try page 515.
515.
I'm extremely grateful. Sorry. What? Yes, I'm extremely grateful to Lord Briggs. If you see there's dotted lines, members of the board, marked on that Ordnance Survey map. What was
various dotted lines shown on this map.
If you look near the numbers 36.16,
yes, yeah,
you'll see a dotted line there, which runs along a continuous line. Well, that is Le Sommet, which is on the east, and following it up, you then come to two dotted lines. In that area is what's being referred to as the dogleg.
Thank you.
And so the continuous line is the Brayo field. So following that continuous line is Le Sommet, and then up to Le Brayo, the Brayo's field. And what was put, the submission from Advocate Gill was that although this is from 1963, that it would be a reasonable inference for the jurors to draw that that was the same position, the track was in the same position as it would have been in 1960. And Advocate T.
Is that a safe inference? Because as I understand it, the 1963 Ordnance Survey shows the property now called La Roche d'Ouvre on the map, but that building wasn't built, was it, in 1960? So one asks, if there was nothing at the top of the plan which one would particularly want to get to, why should one think that there was a driveway along it, along that marked route, which on the face of it serves that building?
It was, Your Lordship, to provide access. You can see a building there in 1963, and with the various sale-offs of the land, it was to provide vehicular access. That's something there's no contest between the parties on. And Advocate T accepted that it was a reasonable inference. She actually accepted that point, conceded it, that you could extrapolate back, and I'll provide the reference for you that in due course, you could extrapolate back to 1960. So there was no contest between the parties on that point. And therefore the jurors made a finding that effectively the bourne would have been laid along the western boundary of that track, which is pretty much where it's been since 1960. Nothing's changed.
Recording Lord Hodge, so I'll go to mute.
So in fixing the boundary, and in fact what you find on site when you go out and when the jurors conducted the feu de justice, the alignment is consistent with what you see in that 63 Ordnance Survey map.
In the Netherlands and not in England.
And that's highly material.
Does that mean then that the description of the driveway in the title, talking about its eastern boundary being along the Breho field and there being the dogleg, so the eastern boundary being on the Breho field, then top of Le Sommet, i.e. a dogleg, that is simply inaccurate?
Yes, I don't think it cuts across that, because what the Ordnance Survey map assists with is fixing the western boundary, because we know that in the dogleg, to use that expression, it's greater than 10 feet. So where I believe it assisted the Royal Court and should assist the board is fixing the western boundary.
This is the...
I understand your argument about the western boundary, but if we look at this map, the route is almost straight, a very slight kink further up when the road finally runs parallel to the Breho field. But apart from that, it's almost straight. How is that consistent with the plan envisaging a dogleg and envisaging the road hugging the boundary of the Le Lacheur land at that time?
When the draftsman of the map was doing, he was drafting what was there. He wouldn't be, he or she would not be looking at title. And then your line of questioning, sir, is highly material to then the observations of Lord Justice Bridge, again back at page 48 of the Court of Appeal judgment.
And Credit Europe Bank NV. This is a case about whether the courts of England and Wales
So what the evidence of Mrs. Harrison, which was unchallenged and which is accepted by the court, is the driveway which she came to in 1968 had basically remained unaltered, and it's still there to this day. Because the neighbours to the west, the Hardings, make no claim to it. And it's been there from at least 68, and if the finding of the jurats is accepted and advocate accepted, you could extrapolate back, then that driveway's been there since 1960. And the owners of the property on the west do not assert title to it. And helpfully, Lord Justice Bridge provides again some very useful guidance to us. This is at paragraph 83 on page 48. And if you'll permit me, members of the board, I will read that. It says, when a conveyance plan, which is said to be for the purposes of identification only, shows a boundary line which differs in detail from some physical feature on the ground, which the conveyance otherwise indicates as the intended boundary line. So what we've got here is des bornes entre deux, which would be the physical feature on the ground, which is intended to be the boundary line. It is clear that the latter prevails over the former. So des bornes entre deux would prevail over the plan.
I can understand readily what Lord Justice Bridge is saying if the physical feature was, say, a river or a wall or something that was readily identifiable as being there all the time. The problem, it might be said here, is that what the Royal Court did and what the jurats were charged with doing is working out where something would have been at the time but isn't there now. That I think is the difference with respect between what Lord Bridge is saying and what the Royal Court is was using this passage for.
Very good, sir. Lord Justice Bridge continues to refer to the plan in such a case in order to ascertain the boundary allows the plan merely to elucidate, not control the parcel. And then at paragraph 85, it was common ground that the approach of the Royal Court in Guernsey would be consistent with that of the Royal Court of Jersey in the Boyle and Highfield Apartments case. And that provides that finally, the Royal Court referred to the decision of the Royal Court of Jersey in Boyle and Highfield Apartments Association and Advocate Gill's reliance on the statement in the judgment of paragraph 32 that, quotes, the extent of a person's ownership of a movable property is ascertained both by the description contained in the conveyance and by the application of that description to the site. So, Your Lordship, you're absolutely correct. Obviously, if it's a river or a feature like that, then it's clearer. But still, what a conveyancer is required to do is to take the conveyance out on site, which is exactly what we did, and apply the words of description of that conveyance as to what can be observed on site. And that also was the function which the jurats were carrying out on the vue de justice. It doesn't, you can't really perform a desktop exercise. You have to, what's material about a conveyance is you take it, look at it, and you go out, you see whether or not the boundaries match up, you see if there's any conflicting boundaries or anything of that nature, which is why, again, when my friend in his submissions was saying, as the Court of Appeal did, they were correct to form a desktop exercise. You don't need to make any findings of fact. Is simply wrong. Again, I'd remind you, the Court of Appeal did not wrongly disregard the findings of the jurates. In other words, they were correct to disregard the findings of the jurates. Keywords in relation to the topography of the site or the position of the boundary mark. Well, that's directly contrary to what Boyle says you must do, which is to take the conveyance out and apply it to what you can observe on the map, which is what conveyancers do every day of every week of every month of every year. And it's also entirely consistent with what Lord Justices Buckley and Lord Justices Bridge were urging as the correct approach, because in the corner of the dogleg, the land was about 5 feet high. And so when the conveyances took place in 1960 and even 1968, the jurates considered, was it really the intention of the parties that immediately upon purchasing the land, that the purchaser would be required to excavate land which is 5 feet high. You're then thrown into the further position that it wouldn't have been just simply by taking a 10-foot measurement along the Sommet and the Breo field. You would still have to work out what the feature was. And if I can illustrate that point by looking at plan, what's referred to as Plan 17B. And Plan 17B, members of the court, is in volume 3 at page 431.
Could I have the page number again, please?
Yes, Your Lordship, it's page 431 in volume 3.
I think it's probably volume 2, isn't it?
In mine, so it's volume 3, so I do apologise.
As long as we got the page, as we said yesterday, we don't have volume 2 in paper form. I'm not quite sure why that is. Do you know?
Yes, I do. So we sent we couriered the documents and we followed up today, but unfortunately, as a result of the government directives, we were informed that everything went into lockdown and nobody was checking the post, or there's no criticism. It's just external factors, if I can express it that way, sir.
That doesn't surprise me. I thought that would be the explanation.
Can I just make absolutely sure we're looking at the right document? My page 431 shows the driveway running across the middle of a photograph with a yellow and a triangle above it, a blue trapezium on it, and what looks like a derelict white car with a sunshine roof just below it.
Lord Briggs, that is correct. Keenly observed on the car, sir, because you're absolutely correct. Now,
I spent quite a lot of time asking myself whether it was the right document, because it seems to be a photograph rather than a plan. But I think you've laid my concerns to rest.
Your Lordship, I'm grateful. I should explain that in Guernsey, a gentleman called Mr. Colin McClont, a very clever chap, arranged for aerial photographs of Guernsey, and he created Digimap. So often the conveyancers will look at Digimap. And what happened in this particular case was that there was a plan attached to the cause, and which formed part of the cause. And we repeatedly inquired of Advocate T, who was the author of the plan. So we wanted to know what informed the draftsman's drafting, or draftwoman's. And eventually we were told that actually Advocate T didn't know who had prepared the plan attached to the cause, but it had been persons at Carey Olsen.
Is the judgment?
So what happened was about 2 or 3 days before the trial, Advocate T produced her own plan, which is the one we're looking at, which she said was simply an enlargement of the Carey Olsen plan attached to the cause. And the submissions to the court and the arguments made before the court were by reference to what we're looking at here, which is Plan 17B.
Of the court in Aspen Underwriting Limited and
have I correctly understood that the cause plan is at page 13 electronic?
May I just check, sir? You are correct, Your Lordship.
Thank you.
May I ask this? If we look at the photograph as MS431, the Digimap as you've described it, could you please explain to me where exactly the 5-foot-high bank is?
Judgment of the court. Aspen
Your Lordship, at this stage, within the yellow area, there was a bank which was 5 feet high, but Mr. and Mrs. Lovering excavated it. They purchased it and excavated it, but it was within, for all intents and purposes, the yellow triangle was about 5 feet high. So by reference to the photograph, below the, as we look at it, the bottom blue line where the car is, that's the western boundary of the driveway which is situate at La Roche-Douve, and below it the car and that line is the Hardings land, and they make no claim to this driveway. And so if we, what was argued at trial was that the property La Roche-Douve was actually enclave, in other words, landlocked, because the driveway came along, as you see it coming from the right-hand part of the Digimap photograph. Then it turned up the page into the yellow triangle, then had at its western boundary the area in blue, and then came back out again. But the jurors rejected that because they made a number of observations, as did the deputy bailiff. If that were correct, because what was being said was that the area in blue was land retained by the heirs La Lacha. But the whole point of that was the foundation in law for that was that the 1980 conveyance of the neighbouring property. But the Royal Court and the Court of Appeal had already rejected that because it's not titled to this property. That was titled to the neighbour's property, and it didn't form part of our title. And I will come to that, as that's part of question 3, but for you to note, members of the court, that's paragraph 106 on page 52, so there's a reference for you. So again, following it through logically, if they made a fundamental error in law, which we respectfully submit they did, and the Royal Court and the Court of Appeal found they did, this area in blue in any event doesn't exist, because it only exists in the minds of, with respect to Mr. Gilbert and others, by looking at the neighbour's title from 1980, not from 1960, not from 1967. But following it through, if we were to look at title, what the jurors observed was the boundary marks would have been laid across the driveway, and these would be large granite sets, things of that nature, across intersecting the driveway in 2 points, forcing the owners of La Roche-Douve to turn up, if they like, onto land which was 5 feet high. And they said, well, the alternative is that they would have followed the driveway which has been there and is still there in 2020 since 1960. And they said, and so taking into account the topography of the land, which is what is the approach in Wigington, and also the approach of Boyle, where you take your conveyance out and you have a look, and the Hardings aren't claiming any part of the driveway at the bottom, was it the jurors just could not accept that in 1960 or even 67, it was the intention that you would have, the existing driveway would be cut off with granite sets, and then you'd have to go turn into an area of land which was 5 feet high, which would need to be excavated. Furthermore, there was another problem with this plan, because the area in yellow is shown.
I'm sorry, could you just repeat for me once again, please, where you say the granite sets were, by reference to the blue mark?
Yes, Your Lordship. If for the plaintiff's case, rather for the Loverings case to be accepted, the boundary marks would have had to be, if you come from the right-hand part of there's the wording La Roche-Douve, follow the track down, you come to the first blue line. So they would have had to have been laid across the driveway at that point. And furthermore, there would have been, as you come across from the right-hand page, there's a long blue line again. They would have had to have been laid across the driveway at that point, thus intersecting the driveway in 2 points. And so you couldn't use the driveway because of the granite sets. And furthermore, the area of yellow wouldn't have provided the means of access because it was 5 feet high. And
well, the whole yellow area wasn't 5 feet high, as far as I understood. You were saying part of it was 5 feet high. Is that right?
Yes, sir. The material part was if you come from the right-hand part of the page and you turn right, if I can, for want of a better judgment, following Le Sommet, so the boundary with the Sommet and the Breauville, that area there, the area which you would be forced to drive over, was 5 feet high. And what the Guernsey Court of Appeal said in that regard, well, if you buy a land and it's 5 feet high, it's 5 feet high, and that's it. Or look out, for want of a better expression. And the jurors didn't. The jurors, on the other hand, said, well, what was the intention of the parties to the 1960 conveyance and the 68? Was it that they would use the driveway to which they came and was there and was clearly visible, or would they have expected immediately on purchasing to have to excavate in 1960 and 68 in Guernsey an area of land 5 feet high? They felt that didn't accord with the intention of the parties, which they felt would have been to use the driveway which they came to, which is consistent with, in other words, having regard to the topography of the land, applying the conveyance topography of the land, which is what Lord Justice Bridge refers to as the physical features on the ground, and what the Royal Court of Jersey described as the application of that description to the site. And the approach of the English courts as well, which is standard in Guernsey, is you have to look at the topography. So in other words, you go out on site with the conveyance and you see what you can observe.
Mr. Fairbrass, you have the advantage over me of having been to this site, and I'm not asking you to give evidence, but looking down from the sky where this photograph was taken, there would appear to be on the west side of the gravel driveway a fairly well-established, although not entirely continuous, hedge. Looks as if there might be a gap in it just in front of the wrecked car. I'm assuming that you say the jurats found that the granite sets were in all probability placed along that line. That is what you might call the longest of the lines constituting the blue trapezium.
That's correct, sir, Your Lordship.
And I'm right in thinking that there's now quite a well-established hedge there, although we don't know when this photograph was taken and we don't know at what time it was established.
We do have dates, but there's no contest between the parties that that hedge has been there for a very long time.
Yeah.
And we have the evidence of Una Harrison, which was not challenged and was accepted by the court. She owned it since 1968, and she said that the alignment of the driveway had remained the same since 1968, and there had been no challenges to her ownership of the driveway from anyone. So what I do need to draw to the board's attention is that although it's to do with servitude as opposed to ownership, under Guernsey law, the maxim null servitude sans titre applies, which means unless you've got a specific grant of a right of a way, you can't acquire one by prescriptive title. You can acquire title, but you can't acquire a servitude. But it was material and informed the jurate's decision as to the location of Des Bornes that effectively the boundary is where Lord Briggs was referring to. That they say that's where the boundary marks would be, and that's consistent with the evidence of Una Harrison.
Could I just explore that last point with you a bit more? Guernsey, as I recall, although it's 15 years since I sat in the Court of Appeal there, Guernsey does have a law of prescription which allows you to acquire title. But as you say, you have to have, I think, a title that is capable of supporting the prescriptive possession for a servitude. Does that apply also to a title to land or not? I cannot recall.
No, so you can acquire title to land, outright ownership for want of a better expression, but you can't claim a servitude over the land. Yes. You can't claim that your land is the...
Yes, but here what was being conferred was a title, but as I understand it, just as the claimants can't argue other grounds of fault against your firm other than those which they have advanced. So similarly, the argument that Mrs. Harrison had obtained a good title by prescription wasn't advanced before the Royal Court. Am I right about that?
Correct. And I was making the points at Lordship so that I could make sure that I informed the board and presented everything fairly.
Yeah, that's right. No, I just wanted to make sure I understood what the position was, but what you're saying tallies with my understanding. Thank you.
Thank you. Your Lords, I didn't want the court to think that I was inferring because Mrs. Harrison had been using it since 1968 and there'd been no challenge. I was in some way leading the board into the conclusion that she could have acquired, because under Guernsey law that's not permissible. So I was arguing against my position, but hopefully to present matters fairly.
To make sure I do understand that, you couldn't acquire a servitude by Guernsey law, but could she have acquired ownership of the road under Guernsey law? I think you said yes.
The answer to that is yes, but not on the facts, because as Lord Briggs has observed, there are some openings in the hedge, so that the Hardings could exercise access over there. So in terms of an acquisitive or prescriptive title, Una Harrison could not assert exclusivity and couldn't exclude. So again, follows on from the observations of Lord Briggs. And I wanted to make sure that the board was not in any way misled on that point.
That's very helpful. Thank you very much, Mr. Pembroke.
Obliged, Lordship. So again, following it through, there were further problems with the plan which Advocate T prepared, in that along the Brayo boundary, it's described as being approximately 30 feet in length. So it's not a definitive measurement, it's approximately 30 feet. Also, what the jurors observed when they went out on site was the top corner and the bottom corner would be very difficult to fix where it started and finished. That's what they observed on site. Then, when you come along on the boundary with Le Sommet, we don't know how long precisely, how far along the length of that boundary. And what happened was, you'll see in the closing submissions, and I'll take you later, that the learned judge, the deputy bailiff, did what a conveyancer would do in Guernsey law and work your way around clockwise, going through the boundaries. So he said, well, an advocate can say, so you've got this boundary with the Brayo field, and you don't know precisely how long it is, and you can't fix the starting or ending point. She accepted that. Then when you come along Le Sommet, she said, well, I accept I don't know how far along Le Sommet you come. And yet she's drawn it again. And then as you come along the bottom, the base of that triangle, and just pausing briefly, as the judge observed, but firstly, Advocate T, the description in title, though it refers to a triangle, describes 4 boundaries, you've only got 3. And she accepted that point. Therefore, the plan again must be wrong. But when you go along the base of that triangle, it shows as having as one of its boundaries the area outlined in blue. And what was said at trial was that area outlined in blue exists and forms part of our title. First of all, that was rejected by the courts above and below, saying it's not title to this property, it's title to the Hardings. There's also a major difficulty because in the sale off of this land to Mr. and Mrs. Brookfield, the triangular area of land in 1984, the area, the parcel of land which is sold off, has described as its boundary running along the base of the triangle a driveway which was retained by Una Harrison. So for this plan to be correct, it would say, for example, bounded on the south way by the driveway retained by Una Harrison, bounded by land belonging to the heirs Le Lasher, and bounded again by land, the driveway belonging to Una Harrison. And when the learned judge put that to Advocate T, well, that couldn't be correct, could it? She was forced to accept that was correct, so her plan is wrong. And along that base, the whole of that base has to have a retained driveway. So the heirs Le Lasher land, we say, clearly doesn't exist because it's from the neighbour's title. But furthermore, your plan can't be correct because it shows as a boundary one part of the boundary, land belonging to the heirs Le Lasher. The title, when she sold off in 1984, doesn't say that. And therefore, the judge put it to Advocate T, therefore there must have been some land and driveway retained by Mrs. Harrison, and she was obliged to accept, yeah, that must be correct.
I wonder whether that actually takes us very far, though, because I think the 1984 title suggested that the land being conveyed to the Brookfields was itself part of the driveway.
Correct.
Which, on your case, it never would have been.
All the stuff.
Well, what we say, Your Lordship, is that the western boundary is the lower blue bit, and it would include Le Breo and Le Sommet. The boundaries with Le Breo and Le Sommet, because in the dogleg,
even if it's a 5 foot, even if it's a 5 foot bank, that was still correctly described as the driveway.
Yes, sir, because sorry.
I was just going to ask. I think you've described your case as having been that in 1960 there was conveyed the whole of the bit between what we now see as the southwestern, western, northwestern boundary of the driveway and the boundaries of the neighbouring properties to the east and the southeast, as it would be a driveway with a rather large verge on part of it, if one thinks of the driveway as going the whole way from La Roche-Douvre down to the public road. Is that where you're coming from?
Indeed, Your Lordship, because what we know is, if you look at the photograph here and on the plans, you'll see there's a driveway which runs up into the dogleg, which is 10 feet in width, and as it exits to the bottom into La Roche-Douvre, it's 10 feet in width. And the parties agreed, and the courts above and below held that in the dogleg it has to be greater than 10 feet. And one of the reasons for that, as my friend accepted in his submissions to the Court of Appeal, is if you followed it round acutely just taking 10 feet, the angle would be too acute to get a car around. And then the further difference.
I think from the evidence that was led and the submissions in the court below, I don't think the respondents are asserting that this map is precisely accurate. But the fact that it describes the western or northwestern boundary of the triangular or not correctly triangular yellow area of ground as bounded by a driveway does not of itself mean that there was 10 feet of driveway still available as such. It doesn't prove that the full driveway still existed. What I think Advocate T conceded was that the northwestern boundary of the yellow area did not, in fact, adjoin the area which he claimed were retained by the Le Lacher heirs. I think that's as far as her concession went.
Yeah, and she also accepted that there could be an area of land which was of some use. So if you concede that we can put our case in a number of ways, if the jurists were correct to position the Bourne along the edge of the Harding property, on any analysis, there is the same access that there's always been. So that deals with that. Furthermore,
if you win on the western boundary, the triangular area of ground is an irrelevance.
Correct, sir.
Because you claim you've proved a title to what in fact is the relatively straight line of access seen on the 1963 Ordnance Survey map. But if there is some sort of dogleg to be treated as part of the title conferred on Mrs. Harrison and referred to again in Mrs. Harrison's conveyance to the Loverings, then the fact that Advocate T conceded that there would be some driveway cannot, I think, be taken as conceding that there was sufficient driveway for vehicular access.
Yes, sir. And Lordship, that informs the further submission. The basis for arguing that there was not sufficient driveway retained is that there existed an area of land outlined in blue which would belong to the heirs de Lasher. And the basis of that submission was not from title to this property, but rather by title to the neighbouring property. And the courts above and below rejected that, saying it forms no part of our title. So again, if you take that away and find that the courts above and below were correct to make that finding, then the area in blue doesn't exist. It doesn't belong to the heirs de Lasher, and therefore there's no impediment.
Yes, but I fully understand your point. You can't look at a neighbour's title to ascertain what exists in someone else's title. But the argument therefore focuses much more closely on what is the status of the plan, and whether in fact there was ever intended to be a dogleg here at all. I think the third question I asked you to address was what was about the relevance of a neighbour's title, and I think you're covering that as we speak just now.
Your Lordship, you're correct, because unsurprisingly, the three questions which you put to me are all form part of that same jigsaw and issues which this board will need to grapple with. So the case which the Lovering set out, and I mean no discourtesy in referring to Mr. and Mrs. Lovering as the Lovering, so I'd like to stress that's just convenient, is that the driveway passed over land belonging to the heirs de Lasher, which is shown outlined in blue. And the basis in law for making that submission was the 1980 conveyance in relation to the Hardings property. Therefore, if that was an error in law, as the Royal Court and the Court of Appeal held, because it's the neighbour's title, not ours, they can't establish as a matter of law that the area in blue belongs to a third party. And the burden's on Loverings to prove every element of their case. Furthermore, we know that Advocate T's plan, because she told the court, was simply an enlargement of the plan attached to the cause. The cause was apparently prepared by persons unknown at Carey Olson, and the parties involved at Carey Olson dealing with it were Mr. Gilbert and Advocate Morgan. And when...
I'm sorry to interrupt you again, but at the moment I don't see how working out who prepared these plans will assist the board at all, because at the end of the day, your case really rests fundamentally on the proposition that the plan is not relevant other than as a broad indication, and the Bourne govern, and the Jurats have carried out an exercise which is consistent with Guernsey conveyancing, of going and seeing the topography and working out where the Bourne would be. So the history of these plans, where it's conceded, I think anyway, that the yellow triangle is not precise, and that the blue triangle does not, the blue rhombus does not match the yellow triangle, I don't think will assist us unless you can persuade me to the contrary.
Well, what I believe is we do have to look at it, because effectively what the Court of Appeal, taking the boundary of the land as being with the Hardings, instead of determining the extent of the area in blue, in other words, what was referred to as what was retained, because the Royal Court observed that, both the Royal Court and the Court of Appeal agreed that what was sold in 1984 belonged to Una Harrison. In other words, she had title. She didn't purport to sell anything she didn't own. A further observation, with which the courts above and below agreed, was whatever she sold, she still retained part of the driveway. So the question arose is, well, what was the extent of the retained land? Now, the jurates determined that by fixing the boundaries along the Harding boundary, but the Court of Appeal said, oh, we don't need to do that, and therefore we don't do it. All we need to do is to determine the area in yellow, and they said, therefore, it's so extensive, effectively, there couldn't have been access. And what I believe is useful is to look at what they were saying in that regard. They said, in order for the Loverings to succeed, they would need to show that there was no other means of access. I'm just trying to find the reference, Your Lordship. I think I can pick it up most conveniently from my submissions. And the submissions to the board are commence at 2838. And the Court of Appeal at paragraph 150 said they concluded that the 2009 conveyance did not give the appellants any other right of access into the property. Well, clearly there is some right of access, but they didn't determine the extent because Una Harrison retained part of the driveway. Also, Your Lordship and Lady Arden, if I could take you also to page 2842. At paragraph 10, this is from the Court of Appeal judgment at paragraph 139. It provides that's page 2842, sir.
Thank you. Thank you.
And this provides, as the averment in paragraph 5C goes on to state, it was no longer possible for the driveway in its entirety to run along the intended course or otherwise to run over land which form part of the property. This is an acknowledgement of the position that for the defect to have existed, and I've added in there the Loverings, must establish that there was no other route of access to La Roche-Douve within the land which was conveyed to them in the 2009 conveyance. Now we know that there was retained land. Una Harrison did retain part of the driveway. So how you can make a finding that there's no viable means of access without determining the extent of the retained land and hence the western boundary marked by Daybourne isn't clear. So in other words, you determine the area which is sold off. You know that there's a retained driveway in between, and then you have to keep coming down the page, for example, on 431, to work out where the Daybourne are positioned. Because otherwise, in the 1984 conveyance on the sale off, the boundary would have been described as Daybourne entre deux, the same as that with the Harding. So you've got retained land. And what they say is that must establish that there was no other route of access. Well, there must have been a route of access. It's over the retained driveway.
Fuck's sake.
So rather than addressing that issue with respect to the Court of Appeal, they've said that effectively we've got to disregard the area in blue because it only exists, that argument only gets to the takeoff point, the 1980 conveyance of the neighbouring property. It doesn't form part of Python is relevant, which they say it isn't because it's not titled to this property. Therefore, we have a retained driveway, so that immediately cuts across the point that there was no other access to the property, but there clearly was. Lord Hodge, as you observed, then you have to say, well, what was the extent? Because what Advocate T had argued throughout the case, by reference to her Plan 17B, was that the land was enclave. Well, clearly it wasn't enclave. It was retained driveway.
When you speak of enclave in this context, that in effect is landlocked. But would enclave cover a lack of pedestrian as well as vehicular access?
Yes, sir, it would. Your Lordship, it would.
Yes. So a concession that the ground wasn't enclave might be totally consistent with the view that there was some driveway so someone could walk along. But it's not saying that there was sufficient driveway for there to be vehicular access.
Correct.
Thank you.
But, and that, I think, members of the court, if you look at paragraph 11, what they were saying is that there was some driveway which could be of some use. And I think useful, at least I hope you agree with me, to the exchanges, what the court said is that there was no other means of access. If I pick up the story, just looking at 2847, which is paragraph 27,
yes.
How we actually ended up in the Loverings ended up in the predicament they were was that Carey Olsen and in particular Mr. Gilbert and Advocate Morgan were also acting for the bank. So their initial stance was, oh, there's a problem here because the area in blue exists. And at the time that advice was being given to the bank, Mr. Gilbert hadn't conducted a site visit. So in other words, what you have to do as a conveyancer is take the conveyance and go out on site and apply it, having regard to the topography. Now, once Mr. Gilbert had eventually done that on about the 30th of October, you'll see the paragraph 27 refers to the advice of Mr. Gilbert and Carey Olsen. Says Colin Gilbert believes that there is a piece of land, the area outlined in blue, that no one exactly knows where or what size it is. This piece of land may or may not be in the driveway to La Roche-Douve. So when he actually, having given the advice and said, yes, there's this area in blue, part for the present purposes, he was in error in law anyway, because it was derived from the 1980 conveyance. He, as a conveyancer going out on site, couldn't say whether or not, are you talking about an inch, a foot, or whether or not it was even in the driveway. And then at pages 2849, and picking it up at paragraph 33.
Again, before we go into this, can you explain to me how this will assist us in determining the appeal? You will recall that there was an application to extend your grounds of appeal, which you eventually, after communication with us, you decided not to proceed with. How a conveyancer came to make what you say is a mistake may be very interesting, but how does it assist us determine the grounds of appeal, this appeal?
Your lordship was questioning me about the scope, or extent, if I might express it that way, of the concessions made by Advocate T on behalf of the Loverings, which is what I was going to take you through. So could it just mean it's pedestrian, or with a bicycle or a wheelbarrow? And I was going to then say that I believe it's material to that.
But if Advocate Barnes say that concession means something else, and in any event the concession is withdrawn, which he would be entitled to do, then how is this going to help us? I mean, at the end of the day, am I not right that your case really stands or falls on the establishment of the western boundary as being the bourne against the Harding plan?
Lordship, there's 2 points. Firstly, that the pleaded case is not sustainable if the area outlined in blue doesn't exist. In other words, that's the first point. And we say the courts above and below held that the neighbour's title, 1980, forms no part of the title. So that's a fundamental mistake. And if you take that away, that should have been the end of the case.
Well, I wonder about that, because if the Court of Appeal were entitled to look at the plan and say that the plan is available to assist them in ascertaining what the intention of the parties was at the time, and therefore where the bourne were likely to be, i.e. that the parties planned a dogleg notwithstanding the existence of the bank, then the title of the heirs of Le Lacheur would not be relied on at all to reach that conclusion. I'm not going to stop you, but at the moment, Mr. Farash, I don't really see how tracking down what the knowledge of the conveyancers in Carey Olsen was will assist us in this case.
The point being that Advocate T argued the pleaded case, which we had to meet, was that the driveway on 17B passed over land. This was how the case was presented, was on land belonging to a third party, namely the heirs of Lacheur. That's how the case was argued.
Yes, well, but the answer is if there was a dogleg, if the plan conveyed to Mrs. Harrison in the land conveyed to Mrs. Harrison in 1968 contained a dogleg, then whether or not there was a 1980 title recognizing the existence of the dogleg, the answer would be that Mrs. Harrison never owned some piece of land similar to the area of land shown in blue.
In which case, Your Lordship, they couldn't prove, they were unable to prove that the area of land in blue belonged to a third party, and that the driveway was on land belonging to a third party.
Well, I don't understand that submission at the moment, because if there is a dog leg, then the western boundary would not be the Hardings land at all. There would be a dog leg, not necessarily exactly reflected in the Plan 17B, but there would be a dog leg. And I'd understood the Court of Appeal to be saying, we find on construing the conveyance as a whole, that is the description and the plan, we find that there is a dog leg, and we find that the area of ground in yellow, or not taking it precisely, but the area of ground conveyed in 1984 was sufficient to render vehicular access not possible. That I understand is the case. But as I say, I'm not going to stop you. You've got limited time. I will let you proceed, but I do indicate at the moment I don't see studying Advocate T's concession as being a particularly central issue to this case.
Very, very good, Your Lordship. I take that on board. So what I would say is this, is that the area at the dogleg was, the parties agreed, and the courts of held, greater than 10 feet. And what the Court of Appeal was saying was that they could determine that definitively, which of course you couldn't do. If I could take members of the court to page 46. So we're trying to fix effectively the bourne, which is the westernmost boundary of the land acquired. And I'm looking at page 46 and paragraph 76. And what the Court of Appeal held is the incorporation of the words of the description of the land conveyed secundo of the measurements of 10 feet means that the boundary with the Lake Revel land to the west of the land being conveyed can be identified as being 10 feet away from the boundary to the east, which we've already said can be identified throughout its length because it is adjacent at all points with the Breo field and Le Sommet land. This means, in our judgment, that in construing the words of description of the land conveyed, secundo, in the 1960 events, the location extent of the land can be identified definitively. But you can't get the answer from the plan, because the plan's merely identification. So you have to look at the words of description, which are the bourne. So you have to know where to place the bourne to determine the western boundary. And so they say that the location and extent of the land can be identified definitively, effectively as a desktop exercise. And that's what's being urged upon this court by my friend. It's simply a desktop exercise. You can do it. Well, plainly you can't. Because the entrance driveway, for want of a better expression, is 10 feet and it corresponds on site, and the exit is 10 feet. But when you get to the dogleg, it's greater than 10. And everybody agrees that. But what they say at paragraph 76, if you like, you take the argument, you go along, you've got a pole, you keep the edge of the pole on the Sommet and you keep the edge of it on the Breo, and therefore you can determine it all definitively, simply as a desktop exercise. But with respect, that argument tends to fall apart, which you then look at paragraph 78. They say that conclusion is subject to one further consideration. The area coloured blue is shown as having a consistent width, except in the inside of the right angled bend, where the boundary line is curved and the blue coloured area is wider on the side away from the Breo field and the Sommet and would be indicated by a consistent width of 10 feet. So it's not a consistent width of 10 feet what is it? And you can't do that as a desktop exercise, which is what the Court of Appeal did. You have to fix as an issue of fact where the boundary marks are. The Court of Appeal didn't conduct a feu de justice, and we weren't making any, despite the submissions of my friend, we weren't criticising the Court of Appeal for not conducting a feu de justice. Our submission was that they didn't, the authorities are that you have to apply the conveyance to the features on site. The court themselves didn't conduct that. The Royal Court did, and then they ignored the findings of fact of the Royal Court. Also, it might be useful to look at paragraph 87, which is on page 49. This provides, and it follows on from we suggest the falling into error on the test as set out by Lord Justice Romer in Wilson and Green and Lord Justices Buckley and Bridge in Wigington. What they say is this at paragraph 87. Applying that approach to the existence of the curved boundary shown on the plan, which is by way of identification not limitation, numbered 2842, which is referred to in the 1960 conveyance, we have concluded that the land within the curved boundary was included in the land conveyed secunda. The plan is not stating as being for identification only. They have said it's not limitation, it's the reverse side of the same coin. The plan is otherwise entirely consistent with the boundaries described in the words of description. There is nothing to contradict a curved boundary on the inside of the right angled bend, and there is a curved boundary. That the boundary at the only measurement of 10 feet in width is consistent with the boundary being marked by board. So in other words, you can't perform the exercise of just measuring 10 feet because when you get to the dog leg, that breaks down. The western extent is by, and therefore you have to fix the position of the board. And you can't do that as a desktop exercise. The position of the bourne is an issue of fact. And is an issue of fact which was determined following a vœu de justice. So what you can't do is simply sit there and exercise, because when you get to that area, it all breaks down. And so when my friend submits in this paragraph 2.5 that the Court of Appeal did not wrongly disregard the jurates, in other words, they were correct to disregard the jurates' findings. That's 2.5 at 2889. They were stating it positively. They were correct to disregard the findings of the jurates in relation to the topography of the site. Well, that's directly contrary to Walsh and Payne, our Guernsey authority, the Jersey authority, and indeed all English authority, because you do have to have regard to the topography. The position of the boundary marks, well, the Court of Appeal themselves say that when you get to the dog leg, it all breaks down because you've got to do is work out that boundary is marked by the board. So how on earth can you fix the western boundary if you don't know where the bourne are or fix the position? Or disturb any findings of fact as to the defect? Well, of course, Lord Justice Buckley and Ridge was saying that you've got to look at the intention of the parties. So that's another finding of fact. He said, the defect in title speed response was made out as a matter of law by construction of the conveyance. Need to make any findings of fact, but that's because what Lord Justice Buck did and got to ascertain the intention of the party.
I'm afraid, Mr. Phillips, is breaking up very badly, due, I think, to low bandwidth at your end, because I'm seeing everybody else's pictures perfectly clearly. Your visual picture has been poor for about half an hour. That didn't matter, having seen you clearly earlier, but your audio picture, I'm afraid, is now, your audio sound is breaking up so badly, I'm finding it difficult to follow your argument. I'm wondering if somebody in your office is sharing your bandwidth.
So others will be. We're actually on a cable, I believe, and so I do apologise. Equally, you were breaking up a little, and I do apologise for that. So, I don't think internet affects this, does it? I'm sorry. I'm looking at my colleague Holly May Lacroix, who's present. There's only one other person present who's a member of AFR, Mr. Book.
Everyone's
you send an email, just saying get out of the internet if anybody's on. I do apologise, Lord Briggs. Equally, and some of the remarks which have been made by yourself or observations I have missed. So, if I might recap, if it's acceptable to you, Your Lordship, what the submission on behalf of the Loverings to this board, paragraph 2.5, is that in order to determine the western boundary, the Court of Appeal do that without the need to make any findings of fact. Well, firstly, that's to elide a number of issues. The Court of Appeal did not determine the western boundary, i.e. Bourne. What Guernsey Court of Appeal did was determined the size of the area in yellow. It did not itself make any finding as to the western boundary. In consequence, it could not make any determination as to the extent of the retained land. Now, we know that there was retained land affording access. In other words, the question is it pedestrian with a bicycle or vehicular? They themselves say that the Loverings can't succeed unless they can show that there's no other means of access, and the burden rested with the Lovering. But in order to do that, you need to fix the western boundary, which is marked by Bourne. And the Court of Appeal never did that, but the jurists did. So in other words, they didn't reject the jurists' findings as to where the Bourne was positioned, i.e. the western boundary. It did not proceed to make their own finding because they considered they could do it as a desktop exercise. But the desktop exercise which they carried out was not determining the position of the Bourne. So our primary position is that you cannot determine the western boundary of the Bourne by a desktop exercise. You have to go out and look at the topography of the land. And the court themselves did not do that. The Royal Court did do that, and the Court of Appeal did not reject their findings on that issue. They dealt with it by saying, you don't need to do that. We can perform a desktop exercise, not determining what the Bourne are, by simply looking at what was conveyed off, and the remainder wouldn't have been sufficient. But with respect to the Court of Appeal, how do you know that the remainder wouldn't have been sufficient to provide access if you don't know the western boundary and the position of the bourne? You simply can't do it. If you start with a piece of cake and you cut away a piece of that cake, you have to know the size of the cake. You need to know what the western boundary is. And the Court of Appeal themselves didn't do that. And what's being said is, again, without the need to make any findings of fact, and that's an incredibly bold submission, and it's not consistent with what the Guernsey court fined the authority of Payne and Walsh. It's not consistent with the Jersey authority of Boyle and Highfield, and it's inconsistent with the English authorities of Wilson and Green and Wigington, because in construing any conveyances of this nature, you're required to make findings of fact, including the intention of the parties, and where a plan is shown by way of identification, not limitation, and the words of description refer to the boundary feature of, namely, a bourne, then you have to fix the position of the bourne. And you see that, for example, with Lord Justice Bridge at 48, paragraph 80, page 48, where he says, when a conveyance plan, which is said to be for the purpose of identification only, shows a boundary line which differs in detail from some physical feature on the ground, which the conveyance otherwise indicates as the intended boundary line, it is clear that the latter prevails over the former. So in this case, the boundary marks would prevail over the plan, and you have to position the bourne. And that's also consistent with the approach of the in Payne and Walsh, and also in Boyle and Highfield, which says the extent of a person's ownership of a movable property is ascertained both by the description contained in the conveyance, and the description contained in the conveyance is a bourne. That's at paragraph 85, members of court, page 48, and key words, and by application of that description to the site. So if that represents the law, which and Guernsey law, Jersey law, and English law are on all fours on that point, it does involve finding by the conveyance to have regard to the topography, and you have did not do that. That was the first error. Today, where the jurists did
I wonder if you can help me in this regard, just so that I understand clearly what your position is. What? Sorry, take that. I'll say it again. The jurats went to have the bout de justice at a time when the tarmac had already been laid on the triangular area. Is that right?
Correct, sir.
Yes. So what the bout de justice would have shown is essentially the line of the existing drive and the existence of new tarmac as shown on the plan 17B.
Yes, yes, Your Lordship.
Yes. The fact that there was a bank there in the past was something that was a matter of agreement between the parties or the result of other evidence.
What the jurors all were photographs taken by Mr. Woodward of this firm, showing the Royal Court what was there prior to the excavation.
I see. So yes, that's not the bout de justice as such. That would be evidence led in the court, presumably.
Correct. So the jurates were able to compare by way of photographic evidence from the time of the site visit conducted by Mr. Woodward from AFR. What's more, Mr. Woodward was accompanied on the site visit by Mr. Lovering, and Mr. Woodward walked Mr. Lovering and prepared a photographic record as in evidence. And then there was a meeting, obviously, Mr. Lovering, myself, Mr. and Mrs. Lovering, to discuss and work our way around the pot face as to what the boundaries were.
Not strictly his employee.
So the jurates, in coming to their conclusions, weren't simply considering the, if you like, after the event excavation. They had also material of what was there pre-excavation, and taking all of that into, and they also explained they took into account the Ordnance Survey maps, and they took into account the aerial photographs. So they had all of that material, Ordnance Survey maps, aerial photographs, photographs of the land as it lay at the time of the Lovering purchase, and post. And from that, they made a finding as to the position of the board.
Can I just ask, is the best description of the jurate's thinking that which we see at paragraphs 82 to 85 of the Royal Court's judgment at pages 106 to 107?
That is correct.
Thank you.
I'm looking for the point whereby they also say that Lord Briggs, you'll see, for example, at paragraph 85, this is on page 107. There is I should rewind the page. Paragraph 83, it said, in reaching their conclusions on this question of the position of the boundary, the jurates have paid particular attention to the topography of the land as they saw it on the British UCDs. They have related what they saw to the documents in the trial bundle. So contained within the trial bundle, which is informed by the observation of Lord Hodge, were all the photographs taken from the site visit pre the excavation. So they had regard to that. They related what they saw to the documents in the trial bundle. And then it carries on at 84, they having regard to the Ordnance Survey maps, so they looked at the Ordnance Survey maps. And then they carry on at 85, again talking about the Ordnance Survey map. The third Ordnance Survey map is dated 1963. By this time, Mr. and Mrs. Delamere had fully constructed, shown, and the markings of the track to reach the first part of the land conveyed to them by the 1960 conveyance shows that it does not hug the boundaries with the Somme and the field owned by Mr. Bray as shown on plan 2842. Instead, it follows a route from the entry point from Rue de Rougeval, running along the edge of the Somme to begin with, then not continuing round to where the land is bounded by the Bray field, but cutting across to the entry point to the area on which La Folie had been constructed, i.e. the parcel shown on the earlier maps as measuring 20.
Mr. Berberash, sorry to interrupt you. We have lost, at least I have lost, photo recognition of you, but also for the first time, for me, your sound has become very interrupted. I just wonder if my colleagues are having the same difficulty.
Apologies. Could you look at this one? Where's I don't know if Brian's still on the line. I haven't touched anything.
Hi there. Would it be possible for you to
there we go.
connect the call very briefly and try and come back on and see if that resurrects anything?
Members of the board, my picture is showing up in the bottom right-hand corner. Can you still not see me?
I can see you now, and your voice has come back. I didn't mind, with no disrespect, I didn't mind not seeing you temporarily as long as I caught what you were saying. It didn't matter for the simple reason that you were reading from a text, namely the Court of Appeal's judgment, which I had in front of me. But it seems that matters have restored themselves. So please continue.
Please accept my apologies. So as you say, Lordship, I was reading from paragraph 85, and it carried on after the reference to the land measuring 20.9 perch. The jurors further took into account that Advocate Gill had invited the court to extrapolate backwards in time to conclude that this tract could be regarded as following the historic route of gaining access to that area of land, and which would have existed in 1960 when Mr. and Mrs. Delamere purchased. Advocate T acknowledged on behalf of the plaintiffs that this was a reasonable approach to take and did not argue that such an extrapolation is impermissible. So that would, again, fix the western boundary as and the position of the Bourne as running along the Harding land. And it was accepted, well, that there's evidence to support that finding of the jurates, which is namely what you see on site and the topography. Furthermore, the Ordnance Survey map, if you extrapolate back in 1963 to 1960, again, there's evidence there to support that, and that was regarded as a reasonable extrapolation. Again, that puts the boundary, the Bourne, along the Harding property. And that's what the jurates did. So there is a foundation, and also Una Harrison's evidence, albeit that's only from 1968 onwards. In other words, if we can start at 1960 and say it's been there since 1960, and the western part of that got in that position from 1960, and we get there by extrapolating back, which is accepted as a reasonable approach. And then you pick it up from 1968, Una Harrison's evidence, and from 19 on this today, 2020, the western boundary with the Hardings is still the same. So we can take, so could the jurates, in fact, place the boundary marks along that edge? Because there's no suggestion and there's no argument that those boundary marks would be being placed on land belonging to the Hardings. And then you ask yourself, well, does that mean you're on somebody else's land? Well, that argument only gets to the take-off 1980 conveyance. Doesn't form part of title to this property, but forms title to the neighbour's property. And the Court of Appeal themselves agreed with the Royal Court that it's not right to have regard to it because it doesn't form part of title to our property. So what the net effect of that means is there's no good reason to interfere with the positioning of the Bourne on the western side along the Harding boundary. And indeed, the Court of Appeal did not disturb the finding of fact that that's the position, because they themselves finding as to position of the bourne on the western side, because had they chosen to do so, they would have had to explain by way of a reasoned judgment
Mission of Revenue and Customs,
the basis for rejecting the jurate's findings. In other words, that somehow the Royal Court had fallen into error in law as regards, if you like, the Lalash's land, but in fact they agreed with the Royal Court. And as an issue of fact, or also another ground, did the jurates take into account matters which they shouldn't have done, or they looked at what they observed with their own eyes, the topography, they looked at the Ordnance Survey map, they looked at the aerial survey map, they looked at the photographs taken at the time by Mr. Woodward, and they took into account the evidence of Una Harrison, which was only, so it couldn't be said that they took into account evidence which they shouldn't have done, so there would be no basis for the Court of Appeal to reject it. And for argument that there are factors or evidence which the jurates should have taken into account, but which they didn't. On that analysis, there would simply be no basis for the Court of Appeal to reject the determination of the jurates as to the western boundary and the position of the bourne. So if they were going to explain that, they would have to say, well, this is why. But in fact, they just didn't do it. They said, oh, we can determine the size of the area in yellow as a desktop exercise, and we don't need to determine the position of the bourne, i.e. the western boundary, but that's clearly not correct. And you also would have to explain, well, on what basis would you be rejecting the jurate's determination? Well, it can't be because they took into account things they shouldn't have taken into account.
Just to let you know, you have 3 minutes left in your submission. So I wanted to give you a chance to make sure you've said what you had to say. Thank you.
Right. So if I could quickly take the court to page 2889. And I'm looking here at paragraph 2, which is, it says, in summary, the respondent's case is that the Court of Appeal. So looking at paragraph 1, what we say is that the Royal Court's approach is should be preferred to that of the Court of Appeal, because as much as anything else, they got the test wrong. As regards 2.2, it says, ought not to be criticised for carrying out a judice which was unnecessary and which the appellants never invited the court to undertake. We make no such criticism of the Court of Appeal.
Is the judgment.
The issue which we have is that they didn't having not carried out their own, you couldn't determine the area in yellow, or indeed the area in blue, or the driveway as a desktop exercise. That's the first point. And the second point is the jurates did carry out a judice justice and determine as an issue of fact, and there was no basis to reject it. 2.3 did not disregard the principle of ascertaining the land conveyed by the description and the application of that description to that site. Well, they did as regards the area in blue, because to determine the area in blue, you had to determine the western boundary and the position of the bourne. When they didn't do that, they only determined the area in yellow. 2.4 did not attach insufficient weight or to disregard the party's intentions. Well, clearly they did. The jurates made findings, because when you look at paragraph 2.5, what's argued in 2.5 is without the need to make any findings of fact and constraint. But what Lord Justice Buckley, etc., and others is you must determine objectively what the intentions of the parties are. So 2.4 is contradicted by 2.5. And 2.5 is, if I'm correct and you can't perform a desktop exercise, which is all the authority is to that effect, and the submission effectively that the Court of Appeal was correct to disregard the finding of the jurates in relation to topography of the site, position of the boundary marks. And position of the boundary marks means you determine the extent of the area in blue, and hence the extent of the area retained, or disturb any findings of fact. So that what this says is that they disregarded any findings of fact of the jurates, which was wrong and against all authority. And they say, well, you can do that because you don't need to make any findings of fact. That's against all authority. 2.6 correctly found that a material or substantial part of the land needed for vehicular access had been conveyed away. But that's only one part of the jigsaw. One, they couldn't determine the extent of the area conveyed away simply as a desktop exercise, because all the same considerations apply. And furthermore, you needed to know what the western boundary was.
The judgment.
Those members of the board are my submission.
Thank you very much indeed. I will now ask Advocate Barnes to begin his reply until the short adjournment. Thank you.
Right.
My lady and my lords, what I'm proposing to do is to deal first of all with the three questions that were asked yesterday, and then to make two observations about the 1984 conveyance, which I submit will help us see the extent of the land that was sold in 1984, which formed part of the driveway. And finally, I have an observation on the terms of the 2009 conveyance, which throw more light on what was evidently intended in 2009 as constituting the western boundary. But just before I start, I have an observation on something that was said this morning about paragraph 102 of the Court of Appeal's judgment, which is at page 51. In paragraph 102, Judge of Appeal Logan Martin is saying that in this situation, we reached the same conclusion as we did in the case of plan number 2842, as it was annexed to the 1960 conveyance, and for the same reasons. The only difference is that the plan is referred to in the 1968 conveyance as indiqué sur le plan, but these are not words of limitation. We are satisfied that the 1968 conveyance conveyed secundo all of the land showed coloured blue on plan 4782, including the curved boundary on the inside of the right angle bend. And that was the same land as shown on the plan number 2842, which was conveyed by the 1960 conveyance and the 1967 conveyance. The point I'm wanting to emphasize is that where they refer to it being indiqué sur le plan, they're saying these are not words of limitation. So they're making it clear that they do not regard this plan, and for that matter, the earlier plan, which is the root of, which forms part of the root of title, as being to any extent for identification only, but being very clearly by way of limitation. That was the point that I wanted to make in relation to that earlier observation. On the questions posed yesterday, the first one, the status of Plan 4782. My submission is that it had been brought in as part of the specific description of the property without qualification, and that it forms the equivalent of a verbal description. It had the same status as the other boundary descriptions. The only part undefined by the descriptions and the reference to the 10-foot in width was the curved section at the right angle on the plan, and the plan supplied the definition of what the boundary was at that point. So the plan 4872, which serves exactly the same purpose as 2842, shows clearly the hedge with embryo field, which is a feature which has always existed throughout the history of this site. And it shows the hedge which forms the boundary of Le Sommet, which equally is a boundary feature that was there at the beginning and is still there now. And the measurements, 10 foot in width all the way down, and the reference to a driveway 10 foot in width give us almost everything we need to know about the position of the western boundary. So without reference to the plan, by reference to the two hedges with the Braille field and the Sommet, we have already got most of our western boundary, because we know it's in boundaries. The only gap in the description is this curved area. And I'm probably confusing everyone by holding up this plan, but it may be clear.
Well, Mr. Barnes, you're holding up. Is it plan 4782 you're looking at the moment?
It is.
Yes, I think that's at page 430 of the electronic bundle.
Yes. Sorry.
Yes, you don't have to hold it up. We can have it on our screens in front of us, because trying to see what you can point if you want to the particular passages. I think we all have it on our screens. Thank you.
Well, what I can say is that the only part of the boundary description missing from the words used to describe it, without reference to the plan, is the curved area where opposite the right angle bend. And the Court of Appeal concluded that the boundary marks would have been placed along the line of that curve. That was the only thing that the conveyancer couldn't do with words. The rest of it he could describe perfectly well by giving the width of the driveway and its distance from the to set boundaries, that the only thing he couldn't do with words was to describe that curve. And quite naturally, the curve follows as a continuation of the boundaries coming up from the south and the one coming down from the north.
How does that relate to the bank?
The bank, which is said to be 5 foot high or thereabouts. The bank would have occupied some of that area within the dogleg.
So the bank area is part of the driveway, and Mrs. Harrison would have to have walked past.
The bank area would be part of the driveway, and it appears that what may have happened is that the parties took a shortcut. They cut off the corner, and that area may have become overgrown, but they appear to have taken a shortcut if the Ordnance Survey plan is helpful. And what was on site and what's shown on the aerial photographs all suggests that a shortcut was taken so that they came to use land which did not form part of title. And that's what happened in this case.
Thank you.
So referring to Payne and Walsh, which the Court of Appeal relied on, and which is at MS 1069. Turning to page 1071 of the head note of the case, and the last paragraph of the head note, in the present instance, the court found the plan had been brought in as part of the specific description of the property without qualification, and that it formed the equivalent to the verbal description and was incorporated into the verbal description as described by Lord Justice Roma in the passage cited. So that, I submit, is exactly what has happened in this case, and the Court of Appeal correctly applied the provisions of the plan, because rather than placing any limit on what the plan was trying to achieve, the conveyancer had employed it fully to reflect the intention of the parties to establish the precise whereabouts of the driveway. And he'd done so first, or the first conveyancer had done so in 1960 by referring to the plan avec mesurage, which is the plan 2842, which appears at page 429 of the bundle. Yes, we have both plans, 428 and 430 together. So the Court of Appeal summarised the legal...
I'm sorry to interrupt you, Advocate Barnes. In Guernsey conveyancing, what is the import of avec mesurage? Is it saying more than that measurements are included?
It's saying that the way that conveyancing, the way that conveyances have referred to employing plans has varied over time. But in this case, they're saying, here is a plan with measurements, which is equivalent to saying, this is a plan by way of limitation. And we'll see that in both cases, the plans are drawn to scale.
Yes, 52 feet to an inch,
Yes.
This particular one.
Yes, my lord. So when the Court of Appeal came to reach their conclusion on the correct legal position, they did so, as you pointed out in your, effectively in your email at paragraph 86 of the judgment, and they say, in identifying what are the boundaries of land which is the subject of a conveyance, it will always be permissible to look at any annexed plan, even if that plan is stated in the conveyance as being for identification but not of limitation. In that situation, the words of description will rule in the event of a discrepancy between the words and the plan. That is the effect of what was said by Lord Justices Buckley and Bridge in Wigington and Milner Limited. In a situation where an element of the plan is defined, is referred to directly in words of description, such as the reference to the line of demarcation in Payne, the plan will be regarded as having been brought in as part of the specific description of the property without qualification, and that forms the equivalent of a verbal description, to quote Judge of Appeal Collins. That will be the case even where the plan is referred to otherwise as being by way of identification but not of limitation. That is a consequence both of what was the result in Payne and Walsh and what was said by Lord Justice Romer in Webb and Nightingale. So the reference that the first thing I said in drawing attention to a submission that my friend has made about paragraph 102 of the Court of Appeal judgment, the conclusion he drew that that plan, the SEPA, the 4782, was by the use of the word indique, lowering its status in some way, was completely, it was not the conclusion the Court of Appeal reached at all. They very clearly regarded this plan and the previous one as being for limitation purposes. I'm sorry, I can't hear anything.
It is perhaps unfortunate that the Court of Appeal in paragraph 102, if you're right, used the words, these are not words of limitation, rather than these are not words of qualification. Because you're interpreting the court as saying no qualification, while earlier on, I think in paragraph 86, they spoke about the distinction between qualification and limitation. Identification and limitation.
Yes.
But so that there does seem to be a slight contrast. On the other hand, if you read on in the court's judgment, it is quite clear they are treating the plan as governing the western boundary.
Yes, it's when they say what is not a word of limitation, what does not take any force out of the effect of the plan, is the fact that it's referred to as being indiqué sur le plan. But in any event, the root of title is found in Plan 2842, and what was conveyed subsequently can't be, unless some land is sold in the meantime, can't be any greater or lesser than what was acquired in 1960. That is the decisive conveyance. Two things have happened since. An area, some of the red land has been sold, so that the La Roche-Douve comes to occupy a smaller site than the land conveyed in 1960. And then the only other thing to happen to this title since then was the conveyance in 1984, whereby some of the driveway, we know it was nothing other than land forming part of the driveway, was conveyed away to the neighbour. So the third question, whether other conveyances assist in determining the boundary, I've effectively just answered that in the negative. Whatever.
So your position is, insofar as arguments were advanced in relation to the 1980 conveyance, they're not really relevant.
No, if you were looking at a problem with title and you couldn't, there was some ambiguity about your own title, you might look at a neighbour's to see what they had said to try and resolve it. But that won't solve your problem.
Yeah, well, that was the answer I expected both you and Mr. Ferbrash to give, and you're at one on that point. Thank you.
So then,
Mr. Barnes, I wonder if you could help me just with the language of the 1960 conveyance, where it appears on page 440.
yes.
The definition of the description of the land secondly sold starts at the bottom of the previous page, and I think I've understood all that, despite not being good with my French. But if you go to 440, you then get the northern boundary, I've understood that. The southern boundary, I've understood that. Then it's a gisant de l'Est, which obviously being translated means east, which I suppose means that the driveway, the land being conveyed, lies to the east of. And then could you just help me with the words that follow down to des bornes entre deux?
À l'est ou environ des dites maisons, serres et terrains appartenant aux dites bailleurs.
I think that means the land retained by the vendors.
Yes, that's right.
Right.
So
and it tells you that the dividing line between the land being retained and the land being sold is therefore marked by markers between the two, entre deux, And that
Yes.
means, I think, the land sold and the land retained, does it?
Yes, that's precisely it.
Thank you very much.
So now I'm going to move on to a consideration of the 1984 conveyance. Which is at page 477. So the first boundary is on or towards the northeast for a distance of approximately 30 feet by a field owned by Miriam Roubiliad, so the Brau field, a hedge between. So we have that long established hedge that forms the boundary which we looked at on the two plans. And that boundary is said to be for a distance of 30 feet. So if you will permit me, I will hold up my plan and indicate where I think 30 foot comes. So trying to...
Could you raise the plan a bit higher? So, that's fine. Thank you.
So I calculate, not using the scale, but by knowing that the driveway is meant to be 10 foot wide, most of its length, that 30 foot should come there. And we know that it's 30 foot from the next boundary, so it's that area. There's never been any difficulty with establishing the extent of the 30 foot.
Yes, but there was a suggestion that it wasn't visible on the Bout de Justice, but presumably the southerly point of the 30 feet must be the boundary with Le Sommet.
Yes, it must be where the two hedges join, the right angle.
Yes.
The next boundary is given on or towards the southeast by a dwelling house called Le Sommet and land owned by the purchasers, a hedge between. Now, there's no limitation here. There's no measurement to say where this boundary begins or ends. But it seems to me that if the conveyancer is saying that on or towards the southeast, so whatever is towards the southeast, a hedge between, it must be about that extent of the boundary, this southeasterly boundary. And if the conveyancer had wanted to make it smaller, then he might have employed a measurement as he did with the northeastern boundary with the Brau field. So that's not, so that, if that's the correct approach, then we have a reasonable, a reasonably accurate way of describing the triangular area. And the only thing
Yes, there is no description of the length of the Sommet boundary, but presumably it will join where the hedge then existed, sealing off the
yes.
triangular of ground.
Yes, there were two. There were potentially.
Please go on.
There were,
sorry.
There were potentially two guides to establishing the point at which the southeastern boundary ended. One was the presence of the hedge that was then said to exist, which would give us the intersection of that hedge, which bordered the remainder of the driveway, and the Sommet hedge. So that would give us the point. But my submission was that since we don't know where the hedge is now, it might be permissible to draw the conclusion that it was the full extent of the hedge to the southeast which was being referred to. But that I submit that as a possible approach for the conveyancer. That almost gives us all the boundaries until we come up to the northern part, because we know that there is the next description is on or towards the southwest, and the northwest for a short distance by the remainder of the driveway. And all that means is that for the northwest for a short distance, if you like, the nib of the triangle here has been cut off. So we have a...
Could you raise your map again if you're trying to show us something on the screen? Thank you.
So this, there would be the triangle would be truncated there, and I can show that in a better way. But if we look at the plan that was annexed to the cause at page 13, so putting that plan north up, the northwestern boundary we've just been talking about is this area here. Now, whoever drew this plan has decided that it would be of that degree. But we can't really say.
Mr. Barnes, it's Lord Briggs. It looks as if, looking at the 1984 conveyance on page 477, that everybody would have known at the time where the hypotenuse of the triangle ran, because it says the hedge between belonging to the vendor.
Yes.
Am I right in thinking, therefore, that Mrs. Harrison would have hedged off that little triangle between it as a sort of verge and her driveway that she was using, and therefore the hedge, the existing hedge, would both define the line and I think define who owned it, and the text would define who owned it.
Yes, my lord, I agree with that.
Yeah, thank you.
Mr. Barnes, I see that it's just gone past 1 o'clock. Would this be a suitable time to take the short adjournment?
Yes, it would be, but I don't anticipate being a great deal longer.
I wondered if that was the case. Well, we will hear you again at 2 o'clock. Thank you.
I'm glad.